Please, Your Lordship.
Yes.
Lordship, I beg to mention item number 27 of the hearing list.
Yes.
Lordship, the conducting counsel is not keeping well, Lordship. So let it come after 3 weeks, Lordship.
Yes.
No objection, Your Lordship.
Inspector by counsel for the petitioner. After 3 weeks.
Yes, Lordship.
Oblige, Your
Deeply obliged, Lordship. May it please, Lordship. Lordship, I beg to mention item 25.
Item
25.
25. Yes.
Lordship, I'm seeking for a week's accommodation, Your Lordship.
Who's
This
the
matter.
other side?
State, Your Lordship.
No objection, Your Lordship. Same also.
Lordship, similar prayer in item 28.
The respondent here.
Private respondent, yes.
I'm for 1 and 2. I have no objection.
Respondent number 3 and 4.
You have no objection.
I have no objection.
This also. Same also.
Much obliged.
Yes.
May it please, Your Lordship. Lordship, I beg to mention item number 3 from the daily list, Your Lordship.
Admission hearing.
Yes, Your Lordship.
It's part 1 matter, which you do not have to mention it. You mention when the matter is called.
My
Only
humble
hearing
apologies, Your
items
Lordship.
are mentioned.
Yes, Your Lordship. My apologies, Your Lordship.
Yes.
Lordship, item 30, Your Lordship.
Item.
30.
We are mentioning in piecemeal.
Lordship.
Yes.
Lordship, 2 weeks, Your Lordship.
You are petitioner or the respondent?
I am the respondent, Your Lordship.
So go change your side. Yes.
No objection, Your Lordship.
Here the trial court proceeding is stayed, isn't it?
Lordship, matter has already been disposed, Your Lordship. Accused has been.
You are appearing for which respondent?
Respondent number 4, Your Lordship.
You are appearing for respondent number 4. Yes, Mr. Chakravarti, you are there.
1, 2, 3, Your Lordship.
They have come on appeal against acquittal, against discharge.
This is a revision, criminal revision.
Yes, they have come on revision against a discharge. The accused were discharged at the stage of consideration of charges.
So now he has asked for time. Yes, Mr.
One, two, three,
counsel appearing for the
Respondent 1, 2, 3.
praise for and granted
2 weeks, Your Lordship.
2 weeks time. So just say aspect for this one because there is one. Granted counsel appearing for the respondent so and so, so and so. The matter is written for 2 weeks. Yes.
Highly obliged.
Oblige. May I please, Your Lordship, I beg to mention item number 31, Lordship.
Yes.
Yes, Lordship. Conducting counsel is out of station, Lordship. But this matter must become up to 2 weeks, Lordship.
2 weeks.
Yes, Lordship.
Yes. And the state?
No objection, Your Lordship.
Yes, also. Yes.
May please, Your Lordship. Your Lordship, I beg to mention item number 22 on behalf of Mr. K.P. Bhattacharya, Your Lordship.
Item 22.
Yes, Your Lordship. He is not available today, Your Lordship.
Who is the petitioner? How many matters are there?
Oh, yeah, there are 2 matters.
That's a revision application.
My lord. Usually, my matter was heard that it was reserved for order.
That is regarding the sports council.
My lord. Yes.
Can I appear in this matter? There is a time that was involving quite a good amount of money.
10 crore rupees something.
I was probably consulted at certain point of time. Justice, thank you was the counsel for.
Yes, my lord.
This will be listed before other bench.
My lord.
List this matter before any other bench without me. I know many things of this.
Your Lordship, a similar prayer for item number 24, Your Lordship. I've already informed Your Lordship the
Item
petitioner.
24.
Yes, Your Lordship.
No one's
I've
there.
already informed them, Your
You have
Lordship.
informed them.
Yes, Your Lordship.
This is also straightforward by MSI Lingual Learned Counsel may appear for the state respondent. This is matter after
2 weeks, Your Lordship.
2 weeks.
Your Lordship, item 26 on behalf of Mr. S. Sen, Your Lordship.
Other side?
No objection.
No objection. This is also same order?
Yes, Your Lordship.
2 weeks.
2 weeks on behalf of Mr. S. Sen.
The state respondent, isn't it?
Yes, Your
So
Lordship.
you are also state counsel.
Yes, Your Lordship.
That's all right. 2 weeks there also, same order. Yes.
Much obliged, Lordship.
May I please, Your Lordship, I beg to mention item number 23 and bring for 2 weeks time, Your Lordship.
23.
Yes, Your Lordship.
Yes. Mr. Sanghaisha.
Yes, Your Lordship.
He's on bereavement. What happened?
His father expired.
When?
On
Sunday.
He has gone to his place.
He has gone to his place. I think he's on the way
Yes,
he's
sir.
on the way to Shillong, I think.
This is all right. Just let's play it on behalf of the petitioner. This is matter after.
After 2 weeks, Your Lordship.
Let's play it for by and not objected to by the learned counsel of the respondents. This is matter after 2 weeks. Yes.
And the
Supplementary cost list, item number 1, Item number 2.
May I please, Your Lordship?
Yes.
Lordship, like to bring some brief facts of the case here. So as to initiate. Your Lordship, the incident happened on 15.
What incident?
Assault on me, Your Lordship. The petitioner was
What is
assaulted.
this case about? This is a
Your
petition?
yes, Your Lordship.
Under 482. What is
Yes,
that?
528.
Yes. 528 BNS. Yes.
Your Lordship, then 16, he got himself treated in Assam Rifles hospital in DJR. But since he was an army cadet, the petitioner hearing. Since he was an army cadet, his dependency was in military hospital. So they referred him to military hospital. By 17, he got admitted at
He was
military.
assaulted by some people.
Yes, Your Lordship.
On which date and where?
On 15th, Your Lordship.
Where?
At Umrah Riboy.
Rivoy.
Yes, Your Lordship.
And he was brought to army hospital for treatment.
On 17th. But 15th it happened. Since he is at DJR, Your Lordship, he is posted at DJR. He got himself treated at DJR hospital. But since he is an army cadet again, he was referred to army hospital, MH civil here in Shillong, Your Lordship. So on 17, MLC is generated, medical legal case, because he had received fractures, Your Lordship, and hearing loss due to the assault. So that MLC was forwarded to the nearest police station, that is the Kansas Beat House, Your Lordship. Then after that, Your Lordship, since he was for
MLC, medical legal?
medical legal case, Your Lordship.
Medical
It's
legal
like, yes, Your Lordship, that in POXO also it is made, where the narratives of the victim is taken, then the examination is conducted. So, Your Lordship, after that, he went for
to a police station.
Yes, Kansas Trace. So he went for treatment since he had suffered injuries and hearing loss and other injuries, Your Lordship. So when he came back after treatment on December, then he found out that no action has been taken on the MLC as well. So he approached the Kansas Trace. Kansas Trace asked him to file a formal FIR. So 14th of December, he filed a formal FIR. But till 10 days, like nothing, no action was taken. So we had approached this honorable court during the vacation bench.
You have alternative remedy. Why under 4?
Yes, Your Lordship. But after that, Your Lordship, we had approached the concerned SP, DG. Then the case has been registered in the first week of January, Your Lordship.
Apart from them also there are other options, isn't it?
Your Lordship,
There is other legal remedy.
Lordship, the case herein involves some highly influential
I can understand, but then you have to exhaust the remedy. 482 is normally not to be invoked.
But Your Lordship has the power
Yes,
under
Mr.
court.
My lord is absolutely correct, my lord. If my lord, my friend should have approached.
Just because the view of the court apparently helps you, so you say
My lord,
accept it.
he has got two other scopes, my lord. On 173.3, my lord, he has to approach the SP of the police, my lord. If that does not yield, my lord, then under section 175.3, he has to approach the magistrate concerned, my lord. So, my lord, I have got a judgment of Shikari Basu of the Supreme Court. That says that, my lord.
We'll issue notice. Let him think over till the next date.
Yes, Your Lordship.
Still, it will be a futile exercise.
Yes, Your Lordship, may just take a look and then may dispose it off.
Let him think over, and if he let us see which way it goes.
Yes, Your
But then there is a provision, as he says. The law says that.
Your Lordship, there's the MLC. It has been changed right on the face, Your Lordship.
That is okay. That is all different things. 482, we cannot go into all those things.
Cannot.
And even when, as Mr. Gurung has pointed out, there is a provision in CRPC.
Yes, Your Lordship.
If you find that police has refused to register,
No, Your Lordship, it has been registered.
The magistrate will direct.
Your Lordship, the case has been registered. After we approached the court, then we were told
Then
to.
what is the purpose of this?
No, Your Lordship, but investigation is not proceeding. They have just
Same thing applies, my lord.
Case has been registered.
Yes, Your Lordship.
Then we will not entertain this. Why should we entertain this? What is the number of the case?
2-1 of 2025 Umiam PS case. But since it won't be here in my application, Your Lordship, when I filed, it was not registered. But my
So your
prayer.
matter has become infructuous then.
Exactly.
But your lordship, in my prayer, I have asked for investigation, not registration, proper investigation. Your
Once it is registered, that means investigation. Registration is not a formality just for these things they will do it. Once it is registered, that will be investigated. How can you presume that will not be investigated?
You know, first week of January, my statement was taken, but after that, nothing has.
Your statement has been taken.
Yes.
Consequent to the registration.
Yes.
And you have this thing suppressed all those things in your petition.
No, your lordship, this had come. I had filed this application before the registration of the case itself, your lordship.
No, but then you said that okay, this is was filed in December.
Yes, your lordship.
But then now it has become infractious. You withdraw it to it.
You know, my prayer is.
Then we'll not this thing. We'll record your statement and we'll say that no cause of action survives. There is no other option. You see, just cannot. You see, file a case for no purpose.
Your notice may be issued. They may apply.
Why shall we issue the notice? See your prayer. Once it is you yourself is saying that this case has been registered. What is that UMPS case number?
2-1 of 2025. 2-1.
2025.
Yes, you.
And then under section?
Under section 109 subclause 1, 117 subclause 3,
and
126 subclause 2.
Yes.
337.
337.
Yes. 339. 61 subclause 2 and 3 subclause 5
of
BNS.
We'll record it and we'll hold it to you. So then nothing remains there.
Nothing remains.
Hard. Responsible learned counsel for the petitioner. Stop. But this application under section 428 of BNSS. Petitioner has raised his grievance against non-registration of a police case consequent to an incident which had happened on 15 November 2024. Resulting in injuries to the petitioner. The petitioner contended that not a petitioner it is submitted by the learned counsel for the petitioner that after the incident the petitioner was taken to Assam Rifles Hospital, DGR, and from there referred to military hospital Shillong, wherein a medico-legal case wherein after medical examination the matter was referred to the Canchester police station.
Yes, beat house actually.
As a medico-legal case. Stop. The contention, the prime contention in this petition appears to be against the failure of the state authority to register a case and launch a due investigation into the matter. Stop. Mr. Gurung Learned GA has opposed the maintainability of this petition. And submitted that even if the allegation of the petitioner is true, comma, he has a remedy prescribed under law and cannot directly approach this cause under this cause by this application or this cause under section 420 428 BNS to seek redressal of his claims.
528.
528.
Oh, 528. Stop. During the course of the hearing, you have paragraph. During the course of the hearing, it is submitted by the granting counsel or the petitioner that consequent to the filing of this application, comma, a case has been reported, a case has been registered by the Omiam police station bearing Omiam PS case number 21 of 2025 under section 109 within bracket 1, comma, 117 within bracket 3, comma, 126 within bracket 2, comma, 337, comma, 339, comma, 61 within bracket 1 and 3 within bracket 5 of the PNS into the in relation to the incident which had occurred on 15/11/2024. In view of the submission, it remains so at present, you just say so in view of this submission, comma, at present, it appears that there remains no grievance for the petitioner.
Your Lordship, if
at this stage.
direction may be given, that just for the just to expedite the matter, Lordship, just
And no direction is called for at this stage. But, however, it is expected that investigation of the matter, investigation of the above case would be completed as early as possible. With the above, this petition stands disposed of.
highly obeyed.
Item number 3.
Yes.
May it please your Lordship. Your Lordship, in this matter, I'm humbly praying for 2 weeks' time.
Why?
Being that the conducting counsel, Mr. Al-Karim, is on sanctioned leave.
Mr. Al-Karim.
Yes, your Lordship.
It's their case, Lordship. No objection, Lordship.
Why it has come for admission hearing?
Lordship, the matter was
It
first.
is ready for disposal, it means.
Lordship, because they had sought for the record also, Lordship, from the District Council Court.
That
And
has been
so
called for? No.
it was on the last date.
On the
it
previous
was,
occasion, your Lordship.
Oh, yes, call for the records.
Yes, your
Record has come or not? Yes. Yes. It appears from the official dates. Again, you have written 16 on 24 here. It's around 24 or 25. You'll correct it. So we'll record it as 25 here. Still, that habit of writing 24 has not gone. Yes. It appears from the official date 16 on 2025. that the trial court, that the lower court record has been received from the judge, district council court. Stop. Mr.
Appealing doc.
Learned counsel appearing to the petitioner. Learned counsel appearing on behalf of Mr. L. Karim, learned counsel for the petitioner, has sought for adjournment of the matter on the ground of non-availability of Mr. L. Karim. You have entered appearance before.
Yes, Lordship.
You filed your power.
Yes, Lordship.
Yes. MS S. Nangrum has no objection. But S. Nangrum, Learned Counsel, appearing with the respondent, has no objection to the prayer. Stop. Done is a prayer allowed. This chapter 2 weeks. Yes, sir. Yes.
Much obliged.
Obliged.
Item number 4.
Yes, another revision.
This is civil revision, Your Lordship. They have taken steps, and as per the instruction that I have received, Your Lordship,
You are appearing for Mr. Khan?
petitioner.
Petitioner. It's not as government.
No. It's been a long time appearing before Your Lordship with a civil matter.
State is, you see, like it is embedded in such a way to you. So whenever we see you, we see state. See, so what to do?
Your Lordship, we have.
May I please, Your Lordship?
Yes, Mr. Paske.
Your Lordship, I am entering my appearance for respondent number 5, 6, 7, and 8.
5, 6, 7, and 8.
Yes, Your Lordship.
Okay, then what happens to 4?
1 and 4 is still remaining. Okay.
Who are 2 and 3?
These are officials of district council, Lordship.
You will represent
For 2 and 3. There's hardly any cause of action
so
against
1 and
1 and
4,
4 is remaining. No, here's one.
So what shall we do with regard to Mr. 1 and this thing? 1 and 4, Mr. Khan?
1 and 4. Lordship, the instruction that we have received is that the notice has been delivered. We'll just bring in record with an affidavit.
Anyway, then you verify, you file an affidavit.
No, we'll file an affidavit.
Okay.
In Lordship, small request, if this matter can be listed on Monday, because we are asking for an interim stay.
See, until and unless...
No, we'll file an affidavit
Let us
today itself.
We'll have it this thing. You file the affidavit and then we'll just...
No, we'll file it.
Let us go by stage.
No, absolutely,
See,
Lordship.
first we let the service thing be complete, then we'll...
Just
See,
praying,
since there
praying
is,
if this matter can be listed on 10th. Or any other day, Lordship, next week, please.
Just... Mr. Tuske is also there, so now he also will have a say. Yes. Mr. Here, Tuske, Learned Counsel, enters appear on behalf of respondent number
5, 6, 7, and 8, Your Lordship.
7 and 8. The respondent number 2 and 3 are represented by Mr. as that. However, the office note indicates that the service report on respondent number 1 and 4 has not yet arrived. Stop. The petitioner shall verify the status and file a service affidavit in respect of the said respondents, least after a week.
Okay. Obliged. Obliged.
Deeply obliged, Your Lordship.
Item number 5.
Yes, we are also pending for...
Your Lordship, I'm entering appearance on behalf of the decree holder, Your Lordship.
Respondent number 2.
Appear for?
I'm for the decree holder, Your Lordship.
Decree holder means respondent
Respondent number 1.
It's a revision is against a decree.
No, but this is against order passed by commercial court, my lord, releasing the amount of execution.
So why this decree holder after the thing? This is not appealable order.
But these are
Because the runner counsel for the respondent says that he is appearing for the decree holder. So assumption is that once there is a decree holder, then there will be an appeal. By normality, until unless you say something there is. Anyway, whatever the thing. So you will enter appearance on behalf of
respondent number 1, Your Lordship.
How many respondents are there?
The two.
Pramajika?
The two respondents. The other one is National Project Construction Corporation. Mr. Kishore Gautam.
No, that is commercial arbitration execution. You have to make this court understand there will be there is no provision of revision here in the act. Why this is under revision under 227?
Under the Arbitration and Conciliation Act, my lord, only against certain order appeal is maintainable before that, and the appeal goes to division bench.
There is no provision of revision.
No, my lord.
That is why you
under the act there is no provision.
So invocation of 227 is a regular thing in the under the Arbitration Act. Anyway, we'll see to it later.
I'll try to answer this question.
No, you'll have to. You see, this court doesn't know anything about those things. So you have to teach ABCD or something. Right from the basic. You will represent respondent number 1, you will represent number 2. Yes. Mr. So and so, not a counsel, enters appearance on behalf of the respondent number 1, and MS so and so, not a counsel, enters appearance on behalf of the respondent number 2. And as such, the service is complete in this matter. What shall we do now?
Come for hearing.
Hearing. Yes, straightforward by the parties.
Your Lordship, I pray for 3 weeks time, Your Lordship, before
this is matter for hearing after 3 weeks.
Obliged.
Item number 6.
May I please, Your Lordship?
Yes.
My Lord, on 17 December, my Lord was pleased to call for the trial court's records, my Lord.
Yes. Record has come.
My Lord, and my Lord, I also, the item number 6 and 7, these are connected matters, my Lord. There's a, both are connected matters. And my Lord, I have the miscellaneous applications filed under section 430 of the BNSS, my Lord.
That is corresponding to
there's corresponding
389.
389 for keeping suspension of the
Yes.
sentence, my Lord.
389.
Yes, suspending the sentence of. So, my Lord, may I, my Lord, I pray, my Lord, kindly hear me on this while paper books are being readied, my Lord.
What is the?
My Lord, this has been convicted under section 304, the part 2, my Lord, and was sentenced to 5 years of simple imprisonment, my Lord. And the order was passed.
For how long?
My Lord, the judgment, the impugned judgment was passed in the month of November.
Culpable homicide not amount to
Not amount to murder, my Lord. Not amounting to murder, my Lord. So the impugned order was passed on 6th of November 2024, my Lord. 6th of November 2024, the last year, my Lord.
Yes.
May I start, my Lord?
This appeal was preferred after a delay.
No.
Was there a delay?
No, there was no delay, my Lord. There was no delay in this, my Lord. My Lord, here.
Lordship, if I may submit before my friend starts, I mean, today is fixed for call of trial records and list the matter after vacation. So if the trial record has come and if he wants to argue on suspension of sentence, detail, the records would, referring on the records will be important.
Definitely.
So let him expedite the preparation of paper book, and as soon as is possible we can.
For the
This is a better option actually.
No, for the
otherwise we will not know where
See,
to
Mr.
reply.
Yubin.
For the purpose of the suspension of sentence, my Lord, I have all the documents annexed in my writ petition, my Lord, in the criminal appeal petition, my Lord.
Mr. Yubin. See, the submission of Mr. Khan carries some sense. If
My
we have to consider your application
My Lord.
for suspension, that has to be on merit.
Exactly, my lord. Absolutely, my
Why
lord.
don't you prepare paperwork if you have everything ready, and we'll decide it as expeditiously as possible.
My lord,
Take it as a priority if
my lord, that it is okay, my lord. But the thing is that, my lord, Section 430 also very clearly says that pending appeal of the criminal appeal, if the court feels satisfied, and after the prosecutor is giving an opportunity of hearing,
We
can
know that
hearing.
provision of law.
Yes,
the
my
court
lord.
feels satisfied, but that means what? There has to be a reference to merit, isn't it?
Exactly, my lord. So for that purpose, my lord, for that limited
And
purpose, I have
that means initial stage means something. There
My
has
lord.
to be a glaring.
Clearing, my
Yes.
lord. Yes, my lord.
So if
So,
you have to dig too much into the thing for going
glaring
this thing,
part.
so it is better to go for final hearing.
my lord, for that purpose, my lord, I have all the, as I've stated, my lord, I have all the papers annexed here, my lord, clean and typed copies, my lord. So, my lord, that will suffice in my humble submissions, my lord. Because even if paper books come, of course, paper books will have to be prepared, my lord. That will take some amount of time, my lord. So pending then, because, my lord, as far as I'm concerned, my lord, this order is, my lord, not tenable in the eye of law, my lord.
What is the ground for this thing? Why do you say that it is not tenable?
My lord, number one is that there are two star witnesses, my lord, on the basis of which we were convicted, my lord. Me and my brother, we are both siblings, my lord.
Your
We are
sentence is for how long?
5 years, my lord. 5 years. 5 years. So, my lord, both of us were convicted on the basis of two important witnesses, that is PW1 and PW2, my lord, who claimed themselves to be the ocular witnesses, my lord. But there is, both of them are so much of contradicting, they have contradicted each
What is
other.
glaring? Tell us.
The glaring is that, my lord.
Contradiction, we have to go deep into thing. You will say contradiction,
Yes.
then you will reply all those things.
Yes.
Try to understand.
Yes.
You see, suspension of sentence
Yes, my
is not something like that in an appeal.
Yes.
You go in depth to
Yes.
appreciate the merit. It has to be on the prima facie things.
Yes.
See,
No.
so that is why this court
Yes.
is saying that there has to be something glaring.
The,
Now, if you say that something, you see, has been done by the trial court, which is apparent on the face of the trial court, definitely.
Yes.
You will definitely try to appreciate it.
Yes.
Now, what is that?
The glaring is that, my lord, that is what I was saying, my lord. The glaring discrepancies committed by the learned trial court is, my lord, is on relying on a statement, depositions of PW1 and PW9, my lord. PW1 and PW9 themselves has contradicted so much, my lord. And
what is the nature of contradiction?
The nature of contradiction.
Where is the evidence of PW9, 1 and 9?
My lord, PW1's evidence.
Please, sit down.
My lord, page 111, my lord, page 111.
Yes, this is PW.
This is PW1, my lord. So before reading this, my lord, may I just take a few moments, my lord, just to explain what had happened, my lord. Me and my brother, my lord, we went, and along with the owner of a taxi, my lord, we went to file an FIR, my lord. Why? Because some boys assaulted us and they broke the taxi also, the vehicle, my lord. So me, my brother, and the driver, my lord, three of us, we went to the police station to file an FIR, my lord. And
this was your vehicle.
This is one of our vehicle, my lord. One of the drivers.
It was a private vehicle.
It was a taxi, my lord. It was
local taxi.
It's a local taxi.
You were an occupant as passenger.
Yes, we were the occupant.
As passenger or
as a passenger, my lord. We were occupant, my lord. So now what happened was, my lord. So we were assaulted, and the taxi was also broken, my lord. So accordingly, we went to the police station to file an FIR, my lord. And our FIR was registered, my lord.
Just tell us the thing before you take us to the relevant documents. Just tell us.
Yes.
Tell us.
So our FIR was registered. It's a the Shillong's other PS or FIRs, and we were sent for medical examinations, my lord. We went for the medical examinations and we came back to the police stations, my lord.
You filed the FIR against certain person.
We filed an
by identifying them.
yes, yes. Although against an unidentified persons, my lord, we filed an FIR, my lord. So we were sent to the medical examinations by the police, and we got the reports, and we went back. By then, my lord, there was a there was a report, my lord, that some altercation had happened, and as a result, somebody died. As a result, somebody died. So assuming, my lord, assuming that it was an altercation between us, the people who has originally went and filed an FIR, and the people who got injured and some succumbed to the injury, my lord. So we were accordingly detained in the FIR filed by the other person there, my lord. So that is how, my lord, that is how the case happened, and where we.
So it means a death took place in the place.
Where
you allege that you were assaulted.
We were assaulted, my lord. So now, my lord,
And
that
then,
is yes.
You see, the police detained you.
Then the police detained us because it is a case that somebody died. It is a case somebody died because we went to complaint. Somebody assaulted us. Somebody died.
But it is from the same incident. Resulted from the same incident.
Related from the same incident, my lord. So that is how the case was generated against me, my lord, and me and my brother, my lord. So now, my lord, now coming back to the PW1, my lord, where accordingly we were arrested and all this thing happened, and we were seen because when this person came to file an FIR, the brother of the deceased came to file an FIR. They've seen us in the police station, my lord. They've seen us because police has detained us on suspicion.
These are nothing glaring. You see,
No.
Something, you see,
yes.
If you have to harp on those things,
yes. No.
I don't think we can.
No, my lord. I'm not harping on those. No. I'm not harping on this. I'm just trying to bring to the sequences so that my lord can appreciate
Do you
the
want
clearing.
to say that since they saw you in the police station, they lost their FIR?
No.
They identified you.
No.
Was it something like that?
No, they identified us there because we were detained on suspicion by the police. So this is where I'm saying now because this will show to in the test period also, my lord. Now, my lord. So now, my lord, these two important witnesses, the clearing ones, my lord, that is coming in PW1 and PW9, my lord. Now let's just come back to the depositions.
What is the point us to the relevant part of the deposition, please?
So, so I'll just read, my lord. I know about this case. I'm reading page 111, my lord. It was Sunday, Holy Festival, in the year 2011. The younger brother of the deceased called up his own brother, who was also with me at that time. After that, we went to the spot. The incident had already taken place, and 4 or 5 people came to us and started assaulting both the brothers of the deceased. What did he say? 4 to 5 persons came and started assaulting the brothers of the deceased. Never said assaulted the deceased. But they did not do anything to me. I can identify only 1 out of the 4 or 5 people who had beaten up the brothers of the deceased on that day, and the accused is present in the court dock today. The witness has pointed out to Louis Dong. Cross-examination by so-and-so, so-and-so. It is a fact that in the year 2011, there were many people celebrating Holi. When the deceased brother called up his elder brother by telephone call, we were both in the marketplace. It is a fact that I was, my lord, continue with 113, my lord, because there's a type copy. 113, present at the time when there was a fight at the parking lot. It is a fact that the deceased is my friend, and the deceased during his lifetime is a member of the KSU. It is a fact that both the deceased and his brothers were drunk at the time of the occurrence. It is a fact that I am not working in the parking lot for collecting money. It is a fact that during the fight, they were running here and there, so I cannot identify the other persons, but I can identify only one. It is a fact that the PS is near, but I could not inform as because I was in the shock due to the incident. It is a fact that the deceased was still alive when the police carried him to civil hospital. It is a fact that when the body of the deceased was carried to the hospital, I did not accompany him. The fight has occurred due to heated quarreling about parking fees, and I do not know what is a parking fees. It is a fact that I have deposed falsely. It is not a fact that I have deposed falsely before this court today. This witness, who is considered to be the ocular witness, my lord, never said that the overt act of me, my lord. Hitting by what object? In fact, he says that I am hitting the deceased brother.
We have to have detailed examination, you see. See, we have to go to the injury report, we have to see what is there in post-mortem, we have to see the involvement of weapon, if at all it is there or not. So all those things, you see, it cannot be done in a threshold. You see, like
my lord,
suspension of sentence,
my lord,
if there is something glaring,
my lord,
what you say to appreciate it,
my lord,
we cannot just decide by relying on the evidence. We have to go further beyond.
My lord, now
that is where we need a detailed hearing.
My lord.
See, Mr. Yubin, do one thing. We'll give you an expeditious hearing.
My lord.
Prepare the paper.
My lord, I'll try my best in that case.
You see, more faster you do it. So normally you know the working thing here also.
My
if
lord.
you want anything to be given priority, any hearing, that can be given.
My lord, my lord.
That
My
is
lord,
better.
because my only concern is, my lord, the two innocent boys are languishing in jail.
How many witnesses were examined in heaven?
Uh,
Altogether, how many prosecution witnesses?
13 witnesses. 13 witnesses were examined, my lord. 13 witnesses were examined. No murder weapons.
And who died? A young person or old man or?
This is a KSU member, my lord, a KSU student.
The
He's a
victim
member
is a KSU,
of.
victim
Yes,
is a
yes,
KSU member.
yes. Victim is a KSU, my lord. So, my lord, I will my lord, in a 2 weeks' time, my lord, I'll just prepare.
Just write in the miscase. Hard in the miscase one. Miscase is what? What is the miscase?
136 of criminal application 136.
136. In particular, 136. We just say hard, Mr. P. Even learned counsel for the petitioner.
6 and 7 of all charges.
It appears that a detailed hearing is needed to appreciate the merit of the contention raised on behalf of the applicant. Thus, this application is rejected at this moment. Is rejected at this stage. However, it is petitioner or applicant?
This will be an applicant, my lord.
Petitioner.
Applicant.
However, the appeal filed with the petitioner shall be heard expeditiously. Heard and disposed of expeditiously. Application stands disposed of. This is 136. Okay. And then in the criminal appeal, you just say the office note indicates that trial court record has arrived. The appellant shall prepare a paper book and file this and submit the same within 2 weeks.
My lord, I'll try within 1 week, my lord. Today is by next Wednesday, my lord.
1 week with an advance copy to the advocate on record for the state.
My lord.
List after 10 days.
After 10 days, my lord.
Lordship, I only hope my friend refrains himself from expeditious adjournment.
No, I'll not adjourn.
If he refrains,
You come prepared.
That is the prerogative which he has. He will exercise it.
So court has expressed his mind of expeditious disposal. Only I just request if he refrains from expeditious adjournment. 6 and 7.
6 and
6 and 7.
Without something so glaring, if we get it, then okay,
My
of
lord,
course,
my lord.
definitely this court will not tolerate it. But then what you are saying, to go into all the
Lordship just read out the in chief and
and
the
your
cross.
cross-examination appears to be in more detail than the examination.
I was about to come to that. Lordship,
it happens.
In chief and cross points to one fact that he identified one of the accused.
No, the problem is my lord. There are so many cases where there's a very good cases where, but then
Tell us the law. Say
close-
supposing. Tell us the
Yes.
law. Say supposing something is not revealed in examination in chief,
Yes.
but then that is revealed in cross.
Cross. Yes.
Can it be used for, you know, sustaining conviction or supporting conviction of the accused?
My lord,
If can we say that in examination in chief there is nothing, but then because of the statement in the cross, the accused is found is guilty.
My lord,
Technically, Lordship, it can say continuation of process.
What is the position of law with regard to that?
My lord, this is an evidence, my lord. Whatever, whether in the cross or whether in the whether in the chief
So
or the
there has to be
cross.
there has to be an overall reading.
Overall, yes, my lord.
You're correct. Anyway,
My lord.
thank you.
Obliged.
Item number 8.
Happening at our last order.
Yes.
Mate, this is your lordship. Lordship, item number 8 to 21 are analogous matters.
8 to
21.
21.
Yes. These are the border fencing, your lordship, Indo-Bangla border fencing, which here they have mostly for praying for compensation. Lordship, kindly come to the order dated.
Praying for compensation for acquisition of land.
Yes, Lordship.
For the purpose of fencing.
Border fencing, yes, Lordship.
So these are basically petition.
This is all connected, Lordship.
Seeking
Compensation, Lordship.
Lordship, kindly come to the order dated 4/12/2024. Okay.
But here what happened, my lord, the Indo-Bangladesh border fencing was done sometime in 1990s, my lord.
1990s.
And it was done through the Border Roads Organization, BRO. Now in 2006, government took a decision to fence it with barbed wire with a proper for national security, my lord. So, and this time contract was given to NBCC by the central government, National Building Construction Corporation. And the agreement is
Mr.
that
Shlai is appearing for MGCC.
No,
For the state.
for the state.
Mr. Paski.
I'm appearing for NBCC, your lordship.
Yes.
Now, my lord, initially NBCC did the calculation because what was required that only some realignment was required, and state also did the calculation, and they calculated roughly around 6 crore rupees, and that we deposited with the collector, my lord. Because
These proceedings, these procedures are conducted under provision of Land Acquisition Act.
My lord, second time, my lord. What happened in 1990s? There is no clarity.
No, normally,
Yes, my lord.
it has to be under the Land Acquisition Act.
Now, 1990s, when Border Roads Organization did, state government also does not have any record what compensation was paid and to whom it was paid. 2006, when they call it phase 3 border fencing, is with barbed wire and more secured border fencing. So that time, because some realignment was required here and there, and for that additional land was required, state calculated 6 crore rupees, and we paid that money. Now all the petitioners have come saying that they never received any compensation in 1990s also. And state is supporting them, my lord.
State is supporting.
State is supporting what is the state in the sense that the collector has written a letter to NBCC, my lord, that you have to deposit another is coming to roughly 100 crore rupees now. So this honorable court directed to the parties, all the departments, state, center, BSF, whoever are involved, is to sit together, and a series of meetings were held, my lord. In the last meeting, certain clarification was sought from state government, my lord. That is reflected in the last order. If I may just point out the last order, my lord. This order of 4th December.
How many petitions are there, Mr. Sheikh?
There are 14 writ petitions.
All represented by you. All represented
No,
by
no,
you.
no. I am in item number 21, Lordship.
Some Mr. Day is there, my lord, some Mr.
8
Peterson.
to
I'm appearing for item number 8 to 16.
16.
All right. So they are represented by different councils.
Yes.
Yes. What is the order you are referring to?
The last one I'm just referring to, my lord. 412, my lord. Order dated 4/12/24.
Yes. Yes.
Now this reads, my lord.
Yes.
Mr. So-and-so, learned AG assisted by so-and-so today has produced a covering letter dated 3/12/24, which contains a letter dated 20/11/24 from the Secretary to the Government of Meghalaya Revenue and Disaster Management Department to the Ministry of Home Affairs, wherein the details as to the land that had been taken for water fencing and the amount of compensation is requested has been detailed. It is submitted by the learned AG that accordingly the state government is awaiting further action from the union government. Dr. So-and-so, learned counsel appearing for the union government has submitted that on receipt of the details, the Ministry of Home has asked the state government to provide the award statement of the collector, if any. Mr. So-and-so also submit that further instructions, if any, will be given on affidavit. As the matter has reached this stage list, this on so-and-so, a copy of the communication is taken on board and made part of the record marked as X. So now, my lord, I am awaiting further instruction after that.
So you have to file an affidavit.
My lord, I'll obtain instruction and file an affidavit, my lord. What has transpired after that?
Kindly see to it. If you are using somebody's land, you should pay.
My lord.
Maybe.
But I'm praying for a little longer time, my lord, because it has come from Delhi and maybe it's still in the process, my lord. 3 weeks or 4 weeks time.
Let it be 4 weeks, Lord.
If you undertake to file a favorable affidavit,
it's quite a substantial amount, my lord. The state is asking now.
Now the matter is 2006.
With 100
you are union. If you want, you can pay that, Dr.
We are only a paying agency, Your Lordship.
Now
you take the land of the people. You give us the money, we'll pay to them.
But 2006, the state, they give estimate of 6 crore rupees, my lord. We deposited, now they come, they're saying that no.
Now law.
We never paid compensation. In any case, my lord, ministry is dealing with the matter with the...
Just say hard, Mr. So-and-so, so-and-so. You just write all the names. Name of Mr. Pascal also is there and all. Okay. Yes. Note who is appearing for this thing. Dr. Magical Learned DSJ appearing for the
5 to 8 and 14/15, my lord.
That is GSJ, just do not say here. Okay. 6 grant of further time for updating necessary instruction. To file an affidavit in terms of order dated 4/12/2021. Learned counsel appearing for the petitioner has no objection. Learned counsels appearing for this is a common order passing all the cases.
Yes, common order.
Learned counsels appearing for the petitioners have no objection. Prayer allowed. 4 weeks.
Maybe after 4 weeks, Your Lord.
Further.
Your Lordship, I am appearing for respondent number 9 to 13.
Yes,
NBCC.
that has been recorded, Mr. Pascal. That will be recorded. Okay.
I am in item number 21.
4 weeks. 4 weeks. Just licensing, then list of. Okay. Prayer allowed, list of trouble.
8 to 21, Your Lord. 8 to 21.
All will be same.
Yes, and same order will follow.
Please do something.
Legally obliged.
Those kind of things are very difficult, Dr. Mojika. Records are not found.
But that is the case. That is why state center is asking.
One way court is concerned not to cause unnecessary burden on the government. At the same time, would not like to see that private individuals' land has been taken without any compensation.
That is why government is considering the matter.
If you are considerate to see all those things, if you find that there was no acquisition, at least pay them for the land.
Hearing.
Legally obliged, Lord.
Item number 29.
Yes. This is a matter which was heard by some other court.
No, it was heard, my lord. But
Why all those part hard matters are? Yes. Yes, Mr. Jha.
My lord. Here the petitioner, my lord, is claiming for invalid and disability pension, my lord. My lord, the facts of the case is that, my lord, the petitioner was enrolled in Assam Rifle on 22nd January 1975.
January
1975.
he was enrolled.
My lord.
As?
As a rifleman ORL, my lord.
Yes.
My lord. After serving 3 years, my lord, he was discharged from service, my lord, on 9th February 1978, my lord.
Discharged on what account?
My lord, on medical ground, my lord. Invalid pension.
What is the date?
My lord, on 9th February 1978, my lord.
Yes. What are those orders? Where are those things? Where is the enrollment? Where is the order of discharge?
My lord, the order of discharge is at page, my lord, 34, my lord.
Yes, there is a type copy.
My lord,
yes.
37 is the relevant.
Yes, yes.
My lord.
34A is the type copy. 34 is the discharge certificate, isn't it?
My lord. Page 37 will be the.
Now, this is a discharge certificate, isn't it?
My lord.
Now, prior to that, any order of discharge is passed?
No, my.
It is only the certificate that is issued.
Certificate.
Is it the procedure, Dr. Majika? Certificate is issued in lieu of an order.
Well, the internal orders should be there, my lord.
But then there has
but
to be
basically,
some
what,
sort
what
of
is handed
executive
over to
order.
them?
This is only certificate. We do not know. You know the procedure better. Anyway, yes. Then
discharge on invalid pension, my lord.
Yes.
My lord,
where do you say invalid? Where is it an invalid pension?
My lord, at page 37, my lord.
This certificate starts from page 34.
34, my lord.
It continues.
My lord.
So it's a multi-page certificate.
Certificate. It's a book, my lord. It is some sort of book. It is up to page 38, my lord.
Now that was done in 78.
8.
Yes. Yes, then?
My lord. Waiting for a considerable period, my lord, the petitioner has been requesting the authorities to grant him pension, my lord.
No, if it is invalid pension, it means you are getting invalid pension.
My lord.
Yes. So?
Invalid and disability pension. I have not received a single paise, my lord.
Why, Dr. Majika, why it is like that?
Till date, my lord.
That is the case. That is
My
the
lord,
issue.
they say that I have not completed 10 years of the mandatory period, my lord.
Have any affidavit has been filed?
Affidavit has been filed.
What is the stand you have taken?
They have,
What the law says?
law says that, my lord, I am entitled for that, my lord.
What is that law?
My lord,
Even if we assume
my lord,
that there is something wrong,
my lord,
or even if we assume that you say like that there is somebody is released on discharge on invalid pension,
my lord,
he will receive
entitled
some pension that has to be borne in the rules. You see like that.
Definitely, my lord. It's a
where is the rule?
My lord, it's a after coming to my lord, January 2019, my lord.
What was the rule which was in existence in 1978? The time when you were discharged.
My
Law
lord,
cannot have a retrospective.
my lord, that time CCS, my lord, the CCS extraordinary pension rule was applicable, my lord.
Just that is, you show me how it is applicable. You have to satisfy. You do not agree with his submission, Dr. Majika. If you do not have any reason to disagree, then do not trouble us. Tell us, we will record it and pass some direction asking them to this thing. But then you have to pay him arrear of pension also, with admissible interest, everything now.
My lord, an identical case was disposed of by a coordinate bench, my lord. I'll just place the order. Have a copy?
Is it?
I have.
Granting relief?
Yes,
my lord.
It will cover the issue here.
Well, this will more or less cover, my lord. But this was disposed with certain directions.
Small order.
It's a small order. 3, 4, 5, 6 pages.
Mr. Jha,
my lord, I have.
Yes.
May I read, my lord?
Yes,
please. This is a short order, my lord. I'll read the entire judgment, my lord. The petitioner is before this court by way of the instant writ petition, praying for directions to issue to the respondent to grant and release disability pension as admissible. The brief facts are that the writ petitioner, who was recruited in Assam Rifle on 12/3/1986, while undergoing basic training, sustained injuries on his legs on 28/4/1986. The nature of injuries resulted in causing 40% disability, and the writ petitioner was boarded out of service on 1/4/1988 by discharge certificate dated 18/2/88. The petitioner, from the time of recruitment till discharge, had only put in 2 years and 20 days of qualifying service, but in fact the injury was caused and disability was attributable to service conditions is not disputed. The contention raised by the respondents with regard to entitlement of the benefit of disability pension is on 2 grounds. Firstly, that the writ petitioner did not have a minimum qualifying service of 10 years, and secondly, to be eligible for disability pension, the extent of disability should be to the extent of 60%. Mr. So-and-so, learned counsel for the petitioner, in his submissions, without extensively dwelling on the facts, has maintained that the writ petitioner is entitled to disability pension, and to support his case has placed it a decision rendered by a division bench of this court in the case of Union of India versus Satyanarayana so-and-so, reported in so-and-so. The learned counsel had taken this court through the judgment to show that the case of the petitioner is covered by the judgment in question, whereby this court has allowed the benefit of disability pension while discussing the entire aspect of entitlement. Dr. So-and-so, learned counsel on behalf of the respondent, in reply has submitted that in view of the judgment rendered by this court, the objections that the respondents only have is with regard to delay and latches in approaching this court to seek relief. He submits that the petitioner had been discharged from service as far back as in 1988, and though had sought some relief before a court which however lacked jurisdiction, and come before this court only in the year 2022. As such, he submits on this ground, notwithstanding the other objections raised, the writ petitioner is not entitled to any relief at this stage. I have heard learned counsel for the parties and perused the material on record, especially the judgment placed by the learned counsel by the petitioner. Upon hearing the learned counsel for the parties from the facts of the case as they pertain, it is seen that respondents, though initially by communication dated 18 May 2020 had communicated that the writ petitioner was eligible for grant of disability pension in accordance with the percentage of disability suffered by him as per CCS Extraordinary Pension Rules 1939. However, by subsequent communication dated 13 July 22 had backtracked by holding that writ petitioner disablement should not be less than 60%. This was followed by the impugned order dated 18th August 22 with regard to the qualifying service of service, whereby the disability pension was denied to the writ petitioner on the ground that he had rendered only 2 years and 20 days of qualifying service. In the backdrop of the facts and by applying the judgment rendered by this court in so-and-so, the objections as raised by the respondent have no legs to stand on. For the sake of convenience, the relevant paragraphs of the said judgment are reproduced. The Central Civil Services Extraordinary Pension Rules, Rule 3A, provides for disability. It says that if disablement is attributable to government service, then the claimant claiming the benefits of disability pension can acquire eligibility. In the instant case, there is no dispute that the respondent suffered 20% disability during the course of training. Therefore, he can be said to be entitled to claim the benefits of disability pension. Though a ground has been taken that injury was suffered during the course of training when the claimant was acquiring the competence to perform duty, therefore it cannot be said to be connected with the performance of duty. The argument cannot be acceptable for the simple reason that the respondent was found medically fit at the time of recruitment, and that is why he was admitted to training. Besides having knowledge of the recruitment of medical fitness for continuance in job, generally no one would perform a feat of the training in a negligent manner to suffer serious injury with the debacle of being declared a low medical category. The injury suffered in this case would only be an accidental injury unforeseen by the trainee recruit. At the time of acceptance of respondent for service as a rifleman, there was also no note of any kind of disease or deficiency which could have stopped him from completing his training. Ministry of Personnel Public Grievance so-and-so by Office Memorandum number so-and-so dated 27/10/1997 by paragraph 5.2 also has provided as where the disability pension under CCS EOP rule is drawn in addition to invalid pension under CCS, the minimum limit of rupees 1275 will apply to total of 2 pensions as indicated in paragraph 5.1. Where the disability pension is drawn in isolation, the minimum limit of rupees 1275 will apply for 100% disability. For lesser degree of disability, the minimum limit will be proportionately less. The above extract is relevant for the purpose that the ministry has provided for a lesser degree of disability. The minimum pension limit will be proportionately less. Hence, the stand of the Assam Rifle that since disability has been assessed to be less than 60%, the respondent should not be granted pensionary benefits cannot be acceptable. Besides, there is a distinction between invalid pension and disability pension. Again, Ministry of so-and-so has clarified the position. The invalid pension may continue to be regulated as per CCS pension rules subject to certain minimum amount, and the extraordinary disability pension may continue to be treated as a separate element, and this should be fixed as per the degree of disability. This will be subject to the further court condition that the amount of disability pension and invalid pension in no case exceed the last pay draw. The CCS pension rule 1972 deals with the invalid pension, whereas rule 3 of the extraordinary pension rules provide for disability pension provided that the eligibility of claim pension would depend upon attributability of disability to the service. Accordingly, in view of the facts and circumstances of the case and position of law as applicable, the writ petitioner is therefore held to be entitled to disability pension as paid. However, considering the time taken by the writ petitioner to approach this court for seeking relief by applying the prescription as given in the case of Union of India versus so-and-so, this court deems it fit to allow benefits of disability pension to commence from 3 years before the instant writ petition. Needless to add, the respondent shall compute the pension payable along with the arrears thereon and complete the exercise preferably within a period of 3 months from the date of so-and-so.
This judgment studies has not been challenged.
Not been challenged.
Now, here one thing is that so far as his claim that he was discharged on invalid pension, that is not disputed.
But my lord, because the percentage is
now, is there any difference between invalid and disability?
well, their claim now is invalid pension only, my lord. Because disability pension they have to complete a certain years of service, my lord.
He is claiming whatever is reflected in his discharge certificate. So that is what you should give it. You are not disputing the fact that he was discharged on invalid pension.
Now, my lord, after this judgment, this was just recently rendered passed by this honorable court, my lord, September 24.
Yes, this is this judgment which you have read out.
My lord. My lord, but now his disability percentage, because the amount has to be calculated on the basis of disability percentage, my lord, and he'll be only be entitled to from 3 years.
So what is the percentage of disability?
So that is
once you have rendered him invalid
my lord.
for retention, definitely you have a framework which says with how much disability person can be retained and with how much a person cannot be retained, isn't it? Where is that? That would be the deciding factor. You do not have to take any separate decision on this at this stage at least. Now, when you basically considered him for discharge on invalid pension, what was the percentage of disability assessed?
But that is not reflected in the certificate.
So then, which way will assess?
And now the problem is, my lord, this is 78 case, my lord. We keep record only for 20 years, my lord. There's a statutory rule that you maintain record for only 20 years. Now he comes to court after 45 years, my lord.
Then what happens then? When did you approach this court?
My lord, I approached in 2022, my lord.
Why?
My lord, the petitioner, I have been representing the petitioners when I came to know.
Filing repeated representation.
My lord, even the pension adalat was held by the respondent, my lord. When the petitioners and
Dr. Mojika, why don't you, on the basis of that what has been held in the earlier judgment, why don't you do something from your end?
That is what because how to because maybe after this judgment he is entitled, but how much that is one question.
Please try to just see how it will be assessed now.
That is the difficulty.
Taken to your department
because in this case, my lord, 40% was mentioned, so it was easier for the court or for us
here,
also.
Here also, my lord.
But then one thing is that once you have taken basically considered him for this thing,
my lord, page 60
not fit for retention, you see, and released him on
my lord, page 60, my lord.
Yes.
Page 60, they said to the petitioner in 2021. May I read, my lord? Page 60.
Yes.
Grant of disability pension, my lord.
Yes.
Further to your letter number such and such, 11th May, it is intimated that your case has been examined in detail and we have processed the medical authority for their further consideration. However, competent authority has intimated that in absence of medical document, unable to assess the percentage of disability without pursuing the medical board proceeding. Hence, assessment of percentage disability is required for consideration. In view of above, you are requested to report to the nearest district government hospital and assess the person disability and report be submitted to the authority for needful consideration.
Then what you did?
My lord, next page, my lord.
Yes.
By letter dated 17th August 2021, my lord.
Yes.
I have assessed my disability.
How can you assess?
I am, my lord, medical. Next page, my lord. 62
yes.
is the relevant, my lord.
Yes.
The disability was of 50%, my lord.
Where is that? Disability certificate.
My lord, disability page 62, my lord.
Yes.
Clause C.
Yes, 50% disability.
My lord.
But this is the lordship certificate of 21, my lord. 78, 22 years that side, my lord.
That
21.
time, my lord,
see,
definitely.
See the requirement which is posed by you. See page 60. See the paragraph 3. Page 60, see the last paragraph. That is direction by you. You wanted that. Now, thereafter, that thing, this disability certificate was submitted.
My lord, submitted by
the. Nothing has been done.
Nothing, my lord.
Yes, Dr. Majika, what you will say? Why you are not considered it?
I'll just have it because whether this is from this is Department of Empowerment of Persons with Disabilities. This is Social Welfare Department issued the certificate.
This is by the.
See, this is headquarter DGR branch which has written that page 60. That's a letter.
You are requested to report to nearest district government hospital for assessment of percentage of disability. Same be reported. Report be submitted to this office for our further needful action.
Yes. And signatory is somebody from headquarter DGR Shillong.
Yes, my lord.
Then?
But thing is, my lord, they've asked for it, my lord, but after 45 years, whether this is the same injury for which, because after 45 years.
Can you dispute the requirement which you yourself posed? Then you should not have posed it.
My lord, we have not said that whatever you bring, we'll accept that, my lord.
Then in such a case, where is the thing? You see, you never said that, but then you said that you report to a government hospital, nearest government hospital, and submit a report. Now, if you reject his report, what is that rejection?
Actually, what happened, my lord, when all this happened, the 60% because that came to be clarified subsequently, my lord. So it was rejected also on the ground, possibly, my lord, because it's less than 60%, my lord.
What you did after submission of this medical certificate, disability certificate? What order you have passed from your end?
But page, my friend has not paginated my copy. So just the next page after the certificate, my lord.
Yes.
This is dated 14 December 21. I'll read para 2, my lord. As per the disability certificate mentioned in para so and so, is suffering from locomotor disability due to post-traumatic malunion, something, upper limb with muscular wasting. The disability certificate has been rendered by the district hospital of Gorakhpur, UP, which is a state civil hospital, and possibly because of this is not in consonance with the Central Civil Service Extraordinary Pension Rules. That it recommended the individual be referred to BSF CH Shillong for obtaining the remarks of the surgical specialist in terms of the Central Civil Service Extraordinary Pension. It further intimated that individual of AR Assam Rifle Records forward the injury report court of inquiry to medical branch for determination of attributable to service.
So you recommend him individual to refer to BSF hospital.
My lord.
Then now you have proceeded to certain extent. Now once you have proceeded, bring it to some logical conclusion. Now just come to the next page, page 64. There is again a direction to the petitioner to give you to appear.
My lord, in the BSF.
And then what happened to that?
My lord, the BSF we appeared, but the communication was not given to the authority, my lord.
Communication was not given to the authority
means to the BSF authority, my lord, to convene a medical board proceeding and assess the percentage, my lord. Then useless. Thereafter I issued a legal notice to them.
Then you do one thing. See, Mr. You appear before that hospital now.
I'm ready.
There was no official communication from the department.
From the department to the BSF
so
authority.
that is why you could not be examined there.
Definitely not.
That is what your submission
yes,
is.
My lord, because that is contrary to there is a, my lord, OPD slip of BSF hospital in his name, my lord.
That's OPD. That's my presence there, my lord.
So, my lord, the matter may be disposed of that way, my lord. That he'll appear, the department will determine the percentage, and they pay for 3 years areas in terms of Tarsim Singh's judgment, my lord.
But depending on the thing, if there is fresh cause of action, then you
again
liberty will be given to you.
Right.
Or what? No, but then this is after 2021. If at all you found that after your appearance, because of non-communication by the department, you could not be examined, then why did not you raise that issue?
My lord, I have that's why I have issued a legal notice in that, and plus, my lord, even the amendments.
Legal notice is not this thing. It was progressing. See, it was progressing, and then suddenly you have approached this court. It was not that the department was remaining silent.
My lord, para 46 of the amendments I have made, my lord.
What does it say?
That the honorable petitioner explained that none receipt of the letter by the BSF Composite Hospital Shillong Shillong was personally.
You have said that. You have said that.
My lord.
That is all right.
My
That is all right. But then you see, once the process had begun, that should have brought to some logical conclusion. Then, if the department proceeds, then you do not need any judicial order.
Definitely not, my lord.
Then?
Why would have a petitioner would have invested the money on the advocate, my lord, counsel, my lord? He would have got the relief and enjoyed the at least a pension, my lord.
If you pass a direction to directing the petitioner to appear before BSF hospital on certain occasion.
Well, instead of that, because that is too old, my lord. Now maybe they will like to assess themselves or send it to CRPF. We do not know, my lord. A direction can be that Assam Rifle will reinitiate the proceeding for determining his person disability, my lord. The BSF that particular.
Then again, that process, how long it will take, we do not know.
That's my lord.
Lots of kindly fix a time frame for that 3 months.
What is your age now?
My lord, 80 years, my lord.
Will be 80% disabled now.
Dr. Mojika, that is something. But then you also have approached this court very late stage.
My lord,
all along you could survive without any pension, and suddenly at the
my lord, when the petitioner came to the notification with regards to that he is entitled for the pension, my lord, where even the percentage of the disability is 0%. The government of India has issued a notification that no percentage is also required, my lord.
Will that notification apply to the department? Where is that notification? If that be the thing, then why should we go for determination of this thing? Will not go. Give us.
Well, that's the first time my friend is saying that, my lord. Because even
give him a copy of this.
This judgment of September 24, my lord, says that we determine the percent.
No, if he says that there is a notification, then definitely. But supply a copy to him.
My lord, it is in the annexure, my lord.
Is it?
My lord. That is, my lord, an extra 2 minutes.
Annexure?
My lord, that is
page.
Please, my lord. Page 44, my lord.
Yes.
notification dated 1st January 2006, man.
Yes.
Annexure number 6.
See, this is basically a memorandum which specifically covers the issues. Dr. Mojika, see the head notes or the subject of the office memorandum. Now, this is specifically to deal with a person who has less than 10 years of service qualification due to an injury or disability. Come to page 44 of the writ petition. And
28 July. My friend is not present. Let me copy. It's struggling.
It's a problem then.
What is my annexure number also?
It's not in hearing here. Sorry.
What is it? We'll continue in the second half then. Yes, doctor. We'll continue in the second half. Or
I may prepare for tomorrow.
Tomorrow. Meanwhile, it's just possible to take some instruction also. If that be the, you see this situation where you see department also, it seems appears from the annexure, the department did not reject him his thing. Appears
because then he came to court, my lord,
see,
immediately.
It was not outright. See, like
it's not a rejection case.
It was proceeding. So if something can be done, then why to see drag somebody to unnecessary to litigation and all? Just see if possible. If not, then we'll pass some orders. Because you have once you have moved, then you should have.
Because the department stopped because he issued legal notice and filed a court petition.
Had learned counsel for the parties at some length. The hearing to continue tomorrow. Tomorrow it will be called at the first item of the hearing. Well, yes.
Yes.
Lordship, item number 32, Lordship.
It is there in the list.
Yes, Lordship.
Yes.
Can it come up after 1 week, Lordship?
After 1 week?
Yes, Lordship.
1 week. Yes. No objection.
32.
32, Lordship.
As at the joint request of the parties, list this matter after a week.
Deeply obliged, Lordship.